Welcome to the UK Supreme Court. This is the hearing of the appeal of Bresco and Lonsdale, being heard by means of video conferencing. We're at the moment hearing submissions on behalf of Bresco, being presented by Mr. Arden, Queen's Counsel, and I will pass over now to him.
Well, thank you. Lord, before lunch, I had identified what we said was the first distinct ground relied upon as a basis for the grant of the injunction, and this was the basic incompatibility point between adjudication and the insolvency scheme, and that's the point dealt with at paragraphs 37 to 42 of the Court of Appeal's judgment, Lord Justice Coulson's judgment, and I've referred in that context to what we say is the relevant authority, which is the Shell Pension Fund case. And I can't remember whether I gave the reference, but it's page 1317, and the paragraphs fall between 14 and 26 and start at 1326. Now, Lords, in the interest of time, I wasn't going to take your Lordships to it unless you wanted it. I'd made some fairly short submissions about what we say about that case, about the notion of incompatibility and where that doctrine or that principle is usually applied, and essentially relied upon the submissions that I've already made about the way in which adjudication might work, both in the context of proof and in the context of set-off, to demonstrate why there is no incompatibility. And fundamentally, it's this, or the fundamental point is this, that the use of adjudication in these circumstances is it's used as a tool to assist the operation of the scheme in the same way as any other dispute resolution process, not to frustrate or thwart it. It's essentially, it is just simply essentially that. It's a tool, but no more. And we accept, and we've always accepted, that it cannot and shouldn't be used as a means by which a party may be deprived of the right of insolvency set-off, and nor can we, because it's mandatory. That is all I wanted to say about that. So far as the remainder of this part of the judgment is concerned, as I think I sort of said before lunch, this splits into two categories. One relates to the result. This is paragraphs 43 to 46 of the judgment. And then there are the wider, principally cost-based considerations, which appear at 47 to, particularly 47 to 51. And then towards the end of that, there's a point about the court's resources. Now, so far as the authorities, or so far as the relevant principles to be applied in that context are concerned, we've submitted this. One looks for analogies, and the closest analogy, as it seemed to us, was the circumstances, or the cases of circumstances in which this court has exercised the Section 37 jurisdiction in order to restrain arbitrations. And the analogy, the basis for the analogy, I think, is obvious, which is this, that in each case, what is sought to be restrained is a contractual right to refer a dispute. And so it seemed to us that, given that there is that right, and what is sought is to interfere with it, or to prevent it, or to prevent a party from exercising it, that That probably was the closest analogy, although we accept that there are obviously substantial overlaps in terms of the principles between that sort of case and other cases of anti-suit injunctions. Now, I'll come on in just 2 or 3 minutes to deal with how we say those principles should operate in this case. But can I just say this of my learned friend's analogy, which is the court's the circumstances in which the court will intervene to prevent or to injunct, to restrain a party from presenting a winding up petition. Now, Lords, again, I'd accept that there is always going to be an overlap in sector, or there's always capable of being an overlap in terms of outcome or circumstances in which a jurisdiction may be exercised between these different sorts of cases. But that analogy, we say, is flawed and fundamentally flawed for this reason. Lord, cases where the court intervenes and restrains a company from initiating proceedings or prosecuting proceedings in court, of which Stonegate Gregory is an example, are cases where the court is exercising its own inherent jurisdiction to control its own processes. That's the foundation, that's the basis that's the jurisdictional basis for the grant of the injunctions in those cases. Lord, so far as adjudication is concerned, the court has no power. It has no supervisory jurisdiction in relation to adjudication at all. It has, well, simply no supervisory jurisdiction. And so we would submit that there is a danger in trying to use a case like Stonegate Gregory's, which is the exercise of different jurisdiction, or well, perhaps it's the enforcement of a different jurisdiction or the exercise of a power conferred for different purposes. There's a great danger in trying to use that as the basis for the grant of an injunction to restrain a contractual right. Lord, I have in mind in this regard the position as it is in arbitration. It's sort of a Bremer-Vulcan point. The point that, and the point made in the judgments in Bremer-Vulcan, which is that the court, that even in circumstances where the court might, circumstances of unwarranted delay, even in circumstances where a court might exercise its jurisdiction to strike out an action, the court did not have the same jurisdiction to do that in respect of arbitrations. You're essentially looking at two different things. So we say that that analogy is wrong and potentially dangerous. Lord, so far as Twintech is concerned, that's at 1381. Lord, there you see an injunction to restrain an adjudication. The judge starts off correctly by saying that the jurisdiction should only be exercised in exceptional cases. And the case there was that the adjudicator had no jurisdiction. Now, and so his appointment sorry, Lord, we lost your video, I think, for just about 5 seconds.
I'm afraid you were. Yes, you were breaking up. I don't know if that was the same for everybody, but I wasn't able to make out what you were saying for about 30 seconds there.
I think, Lord, I think it maybe, I noticed your video, your frame, I think that usually means a problem with the bandwidth. So, but it's the first time it's happened, so hopefully it's the only time. Lord, just tracking back, I had just started by, my last part was just a comment on Twintech. I don't know if your Lordship picked up any of that.
Well, you were just taking us to page 1381.
Well, Lord, all I was going to do, I don't think your Lordship necessarily needs to go to it. I was just simply making the point that Twintech was a jurisdiction case. That Twintech was a case where there was no jurisdiction, so the appointment was a nullity. The judge correctly said that the section 37 jurisdiction should only be exercised in exceptional cases, and jurisdiction, or the absence of jurisdiction, can be an exceptional case, even if you're looking, even if one has regard to the principles or look at the application of the principles in the cases that I was going to refer to. The cases that I was going to refer, that's the Savag and Khoury case and the Ministry of Finance and IPA case, 2388 and 1064. Now, the only other thing I was going to say about Twintech is that if one looks on in the judgment, you'll see that the judge does address the vexatious and oppressive ground in the context of cost consequences, and decides that the consequences that the act, or the consequences that the act itself envisages, cannot be grounds for saying that an adjudication is oppressive or vexatious. And we respectfully submit that he's correct, and indeed have made that submission in our case. Now, so those we say are the principles, and those are the relevant authorities. Just repeating. Now, in this case, it's not contended, but in fact accepted, that this is not a case where it's contended that the adjudication here is in breach of a legal or equitable right. And so when one's addressing the further grounds that I've identified in the judgment, it has to be, we would submit, on the basis that it falls within that last category, vexatious or oppressive, unconscionable, however one wants to describe it. So that is the test. We submit, in line with the cases, that the circumstances in which an injunction will be granted are properly to be characterized as exceptional. There were exceptional cases in Ministry and Finance and IPI. That was essentially the prosecution of arbitrations, which the court considered were designed to achieve essentially a collateral benefit, which was the creation of acts of default. But save for that, the court cited my Lord Hamblin's judgment in Claxton, where it was observed that for the most part, this last ground in the context of arbitrations had only been exercised where in fact it had been decided that there was no either that there was no arbitration agreement, or that the arbitrator's appointment was invalid, or he was without jurisdiction. But subject to that, the cases are, hard, to put it mildly, hard to find. Now, Lord, against the background of that and that test and the need to show exceptional circumstances, can we go back to the judgment at 43 onwards? And can I start with the result? And this essentially is the utility-futility argument. And the way in which the judge puts it changes slightly. But essentially it's this, that the award will not be enforced. And he puts it in 4 different ways. At 45, first line, he says, would not ordinarily be enforced. Then he puts it at, sorry, I've lost it. Oh yes, in the same paragraph, he says only granted in an exceptional case. Then at 46, he accepts the submission that it would be incapable of enforcement. And then finally at 50, he talks about resisting summary, that responding party able to resist summary judgment or enforcement as of right. If I could just track back slightly, two authorities that are referred to there are Bouge and Philpott. Lord, can I just stop with, if I could just ask your lordships to look at the paragraph 44, because Lord Justice Coulson relies upon that for the proposition that he makes about enforcement. But in fact, that part of the judgment in Philpott is not dealing with an outgoing claim. It's not a claim by the company against the third party. It's a claim by the third party against the company. And His Honour Judge Pearl is correct. Again, perhaps not quite, to put it, perhaps not quite as highly as he did, but it is pretty much virtually the rule that a judgment, and a judgment, certainly a money judgment, in respect of a claim, that a money judgment will not be enforced against the company because it will be susceptible to proof and liable to be proved. And so that leads on with Bouge. Now, that case has this, and we respectfully submit, highly significant factor, which is that it was common ground between the parties that the adjudicator had got it wrong. And so in those circumstances, and given that that was the common ground at the enforcement stage, it was, we would say, barely surprising that that it was stayed. And perhaps also not surprising that Lord Justice Chadwick observed that that might have been a case where summary judgment should not have been granted, essentially on other grounds. Not that it's not binding, not that it's not a money obligation, but there are other grounds for not granting summary judgment. But that is that case. That is a significant factor in that case. What Lord Justice Chadwick didn't say, obviously, is that this was a case in which adjudication should not have been commenced at all. Now, what this part of the judgment of the Court of Appeal does, incorrectly in our submission, is that it proceeds on a series of assumptions. It assumes that the adjudicator's award will be in favour of the company and against the third party. It assumes, but pausing there, that's not the case. I mean, plainly not the case. It could be the other way. It assumes that the other party will be dissatisfied with the award, will not accept the outcome, and will seek to challenge it. That assumption simply cannot be made in our respectful submission, having regard to the matters that we dealt with before. And it assumes also that the only purpose of the adjudication is to enforce by way of some form of monetary award. And again, I've made my submissions in relation to that, about the utility of adjudication, even if all it does is to settle items or settle matters of dispute in the course of settle. the final assumption that it makes is that it will not be enforced at all. Now, our position is, and what has been, that it may be that when one gets to the enforcement stage, that the court there, with all the material that it has at that stage, may take the view, if the award is against the third party, and if the third party indicates that it doesn't want to accept it and will challenge it, it may be that the court will grant summary judgment, but stay enforcement on terms. That'd be utterly conventional. Not conventional, but it would be a perfect possibility, and we accept that. But you cannot know that, as it were, in advance. That's trying to predict what's going to happen, not only in relation to the award, but in relation to the wider circumstances, in relation to the wider circumstances as they develop between the referral and the time at which it gets to court. It also assumes that even if the third party is dissatisfied and seeks to challenge it, that at the point that you get to enforcement, the court is bound to accept that challenge, that position has merit as to the whole. But there are any number of permutations, both in relation to the merits, in relation to conduct, in relation to the party's attitude to the award, and indeed in relation to the outcome, which in our respectful submission make the conclusions that the judge sought to draw in these paragraphs, conclusions or assumptions that should not be made. It would be, in our respectful submission, it's simply making the wrong assumptions, and that, in a sense, is and trying to predict outcomes, which, in our respectful submission, is, as a matter of principle, correct. Lords, can I just add that? I think that's essentially all I want to say on this subject, except this, that everything that is said in these paragraphs is equally applicable to outgoing claims where set-off is not engaged, and indeed could be said to be equally applicable to companies in administration, distributing or otherwise, and companies that are insolvent and in no form of insolvency process. Now, one knows that in relation to insolvent companies not in an insolvency process, the court does in fact take a nuanced approach to enforcement. It won't enforce automatically. Equally, it won't not enforce. It depends on the circumstances. Lords, we submit that's correct, but we submit that that is applicable to every case, including an outgoing claim by the company in liquidation, with or without set-off. Lords, so far as costs are concerned, and I'm moving on to the wider considerations, Lords, essentially the consequences that are considered to be unfair flow from a combination of the provisions of the Act, the provisions of the Construction Act, the provisions of the Insolvency Act, and the circumstances in which the company finds itself. Lords, none of those, in my respectful submission, and in alliance or adopting in relation to at least the first two of those, what the judge said in Twintech, none of those in my submission can amount either individually or collectively to vexation or oppression. Lord, so far as the court's resources are concerned, we respectfully submit that the court's resources, in a sense, what you're looking at most likely is a shift of courts whose resources, change of courts whose resources are being used. But equally, take again, in our respectful submission, whilst of course I don't downplay the importance, in my submission, it can't be a factor in support of the application for an adjournment. Now, my learned friend has referred to Aztec and Meadowfield, which which are characterized essentially as first instance judges trying to deal with what they consider can amount to exceptional circumstances to escape the consequences of the judgment. And learned friend says, well, look, that's what can be done. That's a sensible course. But the problem with those cases is twofold, and this particularly relates to Aztec. The first is that it invites the parties, but by trying to deal with things at the jurisdiction stage, it essentially imposes conditions on the contractual right to adjudicate, which the Act itself doesn't contemplate. And that, in my submission, as a matter of principle, is wrong. The second point is that it asks the court has to make assumptions which it shouldn't make at that stage. These are matters which should be judged and assessed at the point of enforcement, not attempted to be assessed at the point at which you try to start the adjudication. And the third is this, that it's simply, if you impose conditions, it simply imposes yet another opportunity for a dispute in court as to whether those conditions have been satisfied. And so, for example, I think Aztec took something like 2 days or thereabouts, but a significant amount of cost and time was spent trying to work out whether or not the conditions have been met. And that, frankly, is completely inconsistent with the process that's envisaged and wrong. Well, the other point that I'd make, and this perhaps applies more to Meadowfield, which was an enforcement case, is the suggestion that that the third party should somehow be placed in no worse a position than it would be if the company were solvent. And Lords, obviously for the reasons that I've already given about costs, in my submission, that's wrong. You can't reverse the state of facts. You shouldn't be assuming that you shouldn't be conditioning, you shouldn't be formulating conditions which are based on a false premise. It's quite wrong. So, Lords, in our submission, and to wrap it up, we say that the right principles are as we suggested. Unfortunately, the wrong assumptions have been made, and as a consequence of that, the wrong conclusion has been reached. We say with great respect, the wrong conclusion has been reached in this case, and that this was not a case. Lord Hamlin, I'm sorry, I'm being more careful this time.
Just in relation to utility, can you just help me as to, on the facts of this case, what you say the utility of seeking adjudication is?
Well, Lords, even if it doesn't result, the way in which what the referral notice seeks is the determination of a series of questions, which arise as to the circumstances in which the contract terminated. And so what is sought is whether or not, for example, whether or not Lonsdale were in repudiatory breach, whether or not the breach was accepted. So it's all the issues that you would expect to be raised, but raised as questions, raised by a party, essentially making a claim against a contracting party for repudiatory breach. Now, I think 2 points. Even if it were not enforced, even if there were nothing to be gained by enforcement, but you had a determination of those issues, the utility is you have a determination of those issues. And if you go back to the proof or establishing the items on the account, the determination of those issues would be as useful as the determination of smaller issues of the type that I mentioned. All of these can be seen as useful steps along a process. But Lord, even if assume no enforcement in the sense of no immediate enforcement, what you can gain, which is of significance, is if it's enforcement, if it's judgment but subject to stays, what you can get, and you can see these in cases like Meadowside and Aztec, is terms which essentially require the third party to get on with it. And so, for example, you could have a stay on terms that the party seeking to challenge does so within a certain period of time, failing which the stay is lifted. Now, there's a huge advantage in that, because that means that even though the estate doesn't get the money immediately, it knows that within a finite period of time, which does not equal 6 years, it's going to know whether the third party is going to do something about it, and have the matter determined. So it's really, I'm sorry, I sort of probably should have started with the second first, but the benefit is in both of those respects. But I said a stay. I mean, the other way of dealing with it is by permitting enforcement, but extracting undertakings about distribution. Well, that's not perfect. Something more than that will have to be done, because in the liquidator's hands, the money would have to be ring-fenced, at least for a period of time. So it's the equivalent, it would be the equivalent of the stay. I suppose the mid-ground would be a payment into court. But what you're getting is certainty, and for an insolvent, a certainty within a reasonable period of time, which for an insolvent estate is of huge benefits, significant importance. Lords, I'm sorry. Again, I did overrun my estimate. I do apologise, and I will take my punishment. But those were my submissions. Those are my submissions. So, but obviously, if there's any matter on which I can help, so I know I've dealt with the last point pretty quickly, I'd be delighted. Lord Briggs.
Are you permitting that we should simply discharge the injunction, or remit that question, or deal with the matter on some kind of, and if so, what terms?
So you broke up on the lot. I think the middle was discharge the injunction. My respectful submission is that you should not remit, but should discharge the injunction. This court is in possession. It has everything. It has everything that it needs in order to make that determination. And I appreciate the constraints within which my submissions have to be made, but in my submission, that would be a proper course. Remission would be, in my respectful submission, a waste of what are probably a waste of limited, not a waste, but it would incur further, almost certainly significant expenditure.
Thank you.
If there are no further questions, thank you very much, Mr. Arden. And we'll turn now to Ms. Sinclair.
Thank you, my lord. I will address my remarks in reply, first of all, to the cross appeal, the jurisdiction issue, and then to the appeal, the injunction issue, if I may. On the jurisdiction issue, my learned friend spent a certain amount of time making the submission that in the light of rules as to prospective or contingent debts, in the insolvency rules, in the light of the Court of Appeal's decision in Recalp thing, the right to adjudicate as a contractual right survived the liquidation. It has never been my submission that it did not. I don't think I certainly didn't intend to suggest, and we do not suggest in our written case, that the right to adjudicate as a contractual entitlement is somehow swept away by the liquidation. It remains in a bare sense, along with other contractual rights which have yet to mature, as it were, into debts and which have no commensurable value, no value measurable in money. But what we say is that there is nothing capable of being referred to adjudication after liquidation, because what survives is not properly characterized as a dispute under the contract. And so our submission is that the dispute which survives liquidation in circumstances of insolvency set-off is ultimately the dispute as to the net balance. It has many components. It comprises sub-disputes in the form of contested claims and cross-claims. Some of those will be capable of being formulated as causes of action because the cause of action has crystallized. Others will not, because they will relate to matters which would debts under the insolvency rules alone. So that is the treatment of future debts, contingent debts, and unascertained debts. Matters which the liquidator must give a value to in taking the final account, but as at the liquidation date are not crystallized causes of action. So, my Lord, I wonder if in a sense, my learned friend and I weren't ships passing in the night to a degree on that point. Our central argument, as you see from our written case, is that what survives liquidation with insolvency set-off is not a dispute arising under the contract for the purposes of section 108. What survives, whether it's characterized as a single dispute or a collection of disputes, because all of those matters have to be collected together and addressed by reason of Rule 1425 of the insolvency rules, is a dispute under those rules and not under the contract. Now, that brings me on to the second aspect I wanted to say a few things about in reply. In my submissions, my Lord Hamlin put to me, well, if a dispute as to insolvency set-off, or the dispute which survives insolvency set-off, might be a dispute under the contract for the purposes of arbitration, why is it not under the contract for the purposes of the Construction Act? And my learned friend made a similar submission when he said that, in effect, there is no material distinction between arbitration and adjudication in the post-liquidation landscape. We say that there is. There is because, first reason, the broad permissive approach to the construction of that phrase, which obtains generally in arbitration, does not apply in adjudication. And I took you, I think, to Hillcrest Holmes, where it was part of the ratio that a statutory cause of action was not a cause of action arising under the contract for the purposes of section 108. I did mention to you Murphy and Mayer, and I submitted that Sir Robert Aikenhead's remarks in that case about Fiona Trust were obiter. My learned friend challenged that, so I need to make it good. My lords, you have that decision at page 869 in the bundle. were rather unusual. It was a dispute in relation to the settlement agreement which parties to a construction contract had made when they reached the stage of the construction contract which required them to know their final account. Quite often there are disputes between parties at that stage. Quite often they formalise their agreement because there is an element of give and take and compromise. And that's exactly what had happened in this case. The settlement agreement didn't contain its own arbitration provisions. The original construction contract did. But it did not include the phrase under the contract. It was the NEC form, which in its adjudication provisions has the wider phrase under or in connection with. So what could be referred to adjudication under the original construction contract was a dispute arising under or in connection with the contract. The parties had chosen, as they're entitled to do, to broaden the availability of adjudication beyond what the statute mandates. Now, it was common ground, my lords, that the dispute as to the settlement agreement was a dispute arising in connection with the construction contract. And you see that at page 881. Oh, no, I'm so sorry. Forgive me. Yes, page 881, paragraph 25. It was conceded that the dispute arose within the adjudication provisions of the original construction contract, but in order to try to avoid enforcement of an adjudication decision relating to the settlement agreement, Murphy took a position which the judge quite understandably described as very unmeritorious. In effect, it said, well, there was a mistake in the contractual adjudication provisions. It identified the Technology and Construction Court as the appointing body, the body responsible for appointing an adjudicator once a party notified an intention to refer. Murphy argued the Act doesn't allow the TCC to be an appointing body. Therefore, the effect of Section 108 is to sweep away the contractual adjudication provisions, and the provisions of the scheme are then implied as the default position. Under the scheme, of course, one doesn't have the wide phrase, disputes arising under or in connection with the contract. One has the narrow phrase that is also in Section 108, disputes arising under. So Murphy, in its efforts to avoid enforcement of the adjudication decision, presented this rather convoluted argument to get to a position where the question was whether the dispute under the settlement agreement was a dispute arising under the construction contract. And the reason why what the judge said there about Fiona Trust was obiter is because that central contention failed. And the judge said, no, Section 108 doesn't have the effect because of an error in mentioning a particular appointing body of sweeping away all the contractual adjudication provisions. And so the contractual adjudication provisions stand. And it having been conceded, this is page 881, just above B, Murphy having conceded, as I say, that the dispute was within the scope of the contractual adjudication clause, under or in connection with, the judge did not have to decide whether the dispute was under the contract and what that phrase, taken alone, meant in the context of adjudication. So his remarks were very much, in my submission, very clearly obiter. His decision is in paragraph 28 at the foot of the page. The adjudication clauses in the sub-subcontract survived. It's common ground that they're broad enough to cover a dispute arising under the alleged settlement agreement, because that later agreement undoubtedly arose in connection with the original subcontract. The judge, for completeness, did go on to indicate that it wouldn't have made any difference even if the applicable phrase had been under the contract. You have that at page 884. Paragraph 34, so it wouldn't have made any difference. I would have decided that this settlement agreement operated simply as a variation of the construction contract, so that it was in any event under the original construction contract. So that's all I propose to say about Murphy and Mayer. In other words, it doesn't, in my submission, advance matters. The simple reason why Fiona Trust doesn't apply. My Lord Hamlin has a question.
And obviously, this is a general passage as to the appropriate approach laid down by a very experienced TCC judge. Has it been picked up on in the textbooks as cited as an appropriate approach to adjudication?
My Lord, so far as we're aware, no. It is a fairly recent decision, which hasn't, I think, been reported in the construction series of law reports. We have it in the business law reports, which is a relatively unusual place for a TCC decision to appear. My learned junior will remotely correct me, but we would have looked, happy to look again, but I'm pretty sure there is no comment. Lord, in any event, the established position was, as per the Hillcrest Holmes decision, which we refer to in our written case, that Fiona Trust doesn't apply. And the principal reason, not the only reason, the principal reason that it doesn't apply is that construction adjudication is mandatory. It's mandated by statute. It is not the result of the party's free choice. Now, again, yesterday, Lord Hamlin put it to me that, well, the parties here chose to incorporate the scheme. But that was a choice. That was a choice between a closed set of alternatives, and it was not a choice that could be ducked. The parties had a number of options. They could have used one of the standard form contracts, which all have their own sets of adjudication provisions, compliant with Section 108. Or they could have said nothing, and therefore the scheme would have applied by implication under Section 114 anyway. Or they could have chosen to incorporate one of the other sets of adjudication rules, which are published by bodies such as the Construction Industry Council. It's a fairly popular set of rules, and you will have seen reference to it in the cases. What the parties cannot choose is that a right to adjudicate will not be a part of their contractual agreement. They can, of course, choose that a right to arbitrate won't be part of their contractual agreement, arrangement. Now, Mr. Arden sought to persuade you that it's wrong in some way to regard arbitration as consensual, because in effect, if the parties choose to operate in a given commercial sphere, they will have to accept very often standard terms in use in that commercial sphere. That's not an answer to our point. One can say of any contract term, very many contract terms certainly, that there must have been some commercial imperative, that one party or the other must have felt that commercially it had no choice but to agree that term. Ultimately, of course, the choice that the parties make is to do business in a particular area. Now, be that as it may, that might be the commercial reality, but the law in this country has always regarded the choice of arbitration as a forum for dispute resolution in preference to litigation. It has always regarded that choice as a free bargain, like any other contract term which is not mandated by statute. And that principle is enshrined, of course, in the Arbitration Act itself. And we have that, my lords, at page 505. Forgive me because I know it's very familiar, but it's unusual, this Act, in that it begins with a statement of principle. Section 1 sets out 3 principles, the second of which is the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Now, if the choice of arbitration, therefore, is not regarded as a matter of law in the normal way, as a free choice, then that principle is meaningless. And C, in matters governed by this part, the court should not intervene except as provided by this part. So there is the express principle of restraint, which the law in this country observes in relation to arbitration, which is important in the context of the injunction issue. I'll come back to it. So, my lord, we do say, for the reasons in our written case, and because of this stark difference between a dispute resolution process, I use those, a dispute resolution process, such as adjudication, which is mandated by statute, and one that is chosen by the party. That is the difference ultimately between adjudication and arbitration. I'm sorry, my lord. Briggs. I can't hear you. I'm sorry. I can.
There we go. I'm struggling to understand, Ms. Sinclair. We're here talking about how generously a trigger phrase under a dispute which arises under a contract should be construed by comparison between a phrase which is purely voluntarily included in a contract and a phrase which is still included in a contract but with parliamentary backing that means you've got to put something of that kind in. Why should the fact that Parliament has, having considered the Latham report and prior best practice, regarded this process of dispute resolution as so beneficial within this particular context that everybody ought to do it, or at least contract for it, why should that consideration make one less generous in the construction of the ambit of the trigger phrase?
Well, the reason is this, that the broad permissive construction, which has been adopted in relation to arbitration, certainly since the Fiona Trust case, was explicitly based there upon considerations of the party's choice of arbitration. I think I took you to the paragraphs 5 to 7.
I understand that. I'm simply asking, why does the fact that in this case Parliament has decided that everybody should contract for it because it's such a good thing constitute a reason for being less permissive?
My lord, in a sense, I'm suggesting that one looks at it in the opposite direction.
Yeah.
That one starts from the literal wording, and there is no reason in adjudication to adopt an expansive approach, rather than that one somehow adopts a reductive approach from the ordinary meaning of the words under the contract. We're content with the ordinary meaning. A dispute which arises under the contract, we say, is not a dispute which arises under a statute, such as insolvency settle. My lord, it is also my submission worth remembering that so far as disputes are concerned, of course, arbitration is not a free-for-all. There are limits depending on the particular wording of the clause, and certainly normally the disputes encompassed within the scope of an arbitration agreement will be disputes relating to a particular contract. Now, that conceivably creates a problem in some fact situations, so far as insolvency set-off is concerned. Because if you have disputes under more than one contract, and they don't contain arbitration agreements which allow them to be dealt with together, so that there is a degree of consistency in their resolution, then you have a tension. And that may be the rationale for the what the Chancellor said in Salford Estates and Altamart, which we mention in our written case as a caveat, really. You have it at, the case starts at page 1194. And if I might just give you the reference, paragraph 34 at page 1203. This was a decision in the context of an application under Section 9 of the 1996 Arbitration Act for a mandatory stay because proceedings had been commenced in breach of the arbitration agreement. And there was argument about whether Section 9 could be used to restrain a winding up petition. And in that context, the Chancellor said, if only some unpaid debts in the petition arise from transactions within an arbitration agreement, the concept of mandatory stay under Section 9 makes no sense. Plainly, there is no basis for staying the petition itself, and if the petition proceeds, there can be no reference to arbitration of any of the debts, because the making of a winding up order brings into effect the statutory scheme for proof of debts, which supersedes any arbitration agreement. Now, I accept it's difficult to see quite from that case what the Chancellor had in mind, but I invite you just to note it, because what it indicates is that arbitration is not itself comparable to litigation for purposes of determining post-liquidation debts. It might well have its own difficulties, and therefore, before one proceeds from the position that the liquidator could bring these claims in arbitration to the position that he can therefore bring them also in adjudication, it's worth bearing in mind that there could well be difficulties in arbitration also. And moving on, if I may, to my learned friend's submission that in practical terms, adjudication might well be useful to the liquidator. He took you at some length through the provisions of the rules which govern the process of submitting a proof and the liquidator then reaching a decision on the proof. The first observation we'd make, of course, is that on the authorities, no proof is needed for insolvency set-off to operate. And in fact, it may very well be the case that a creditor with a cross-claim may think it not worth his while to prove. Lonsdale did not prove here when some 3 years before this reference to adjudication was served, Bresco went into liquidation. Lonsdale saw no prospect, this would be typical of many creditors, saw no prospect of a recovery and therefore didn't go to the expense of proving. Nonetheless, if we look at the situation in the context of the process of proof, learned friend emphasized that the processes which, as it were, are faced by the liquidator, he characterized them as iterative. Well, that might be the practical reality, because the liquidator has a duty to put a value to claims. But ultimately, the point at which he has to, as it were, make his decision is the point at which, if we're looking at the proof process, it's the point at which he accepts or rejects a proof, or accepts it in a lower amount than submitted. Interestingly, liquidators commonly refer to that as their adjudication on the proof. But my lord, in circumstances where the liquidator has made his decision, has published his adjudication, which the legislation requires him and not a third party to do, the insolvency rules direct the parties to the court through the appeal process. It doesn't suggest that there is any other forum in which a dispute as to the final account, which by that stage has been taken by the admission or rejection of a proof, doesn't suggest any other forum for that. Now, my learned friend sought to persuade you that speed is important in a liquidation. Adjudications are typically speedy, and that for reasons such as those, the availability to a liquidator of adjudication is a useful thing. What that submission overlooks is that adjudication is a choice between alternatives for the liquidator. It can either do what it does in cases where there is no construction contract within the meaning of the Act, and that's take professional advice so that the liquidator can estimate and value the claims and cross-claims. Or, if it takes the adjudication route, it can delegate, in effect, its decision to a third party. It can do that only with any meaningful result if the other party participates. And if the other party participates, it has to do so at its own expense, because that's the nature of adjudication. Inevitably, adjudication involves time and effort, often extremely intense effort because of the abbreviated timescale. And with the intense effort comes cost. That time and that expense is not justified, we say, when the only product is going to be a decision with an inherent likelihood of error, and which, if it binds the parties at all, it binds only on a provisional basis. And I say if it binds the party at all, because of course the court will not enforce an adjudication decision. That is, I'll come back to this on the adjudication, on the injunction issue. It is clear as a matter of law and the practice of the TCC that an adjudication decision will not be enforced in favour of a company in liquidation. So what does the liquidator get in return for having devoted assets of the company and having devoted resources of the creditor to the adjudication process? He gets a decision by an individual on materials which happen to be available to him at that time and which he is capable of processing, who is not likely to be a lawyer, and who cannot produce a decision which in these circumstances will be enforced by the court. Lord Leggett has a question.
Say to Mr. Arden's argument that at the very least adjudication will flush you out, so to speak. If you choose not to spend any time and money on opposing it, then so be it. But then the liquidator can go to the court and you'll have to have some terms imposed as to how you are going to show you've got a good defence to the claim. At some stage, you're going to have to spend some money to show that you don't owe the claim a balance to the company. And you can either choose to do that in the adjudication if you want, or you can do it later, but it will at least move matters forward.
There was no, certainly on the facts of this case, there's no suggestion that there was any difficulty in bringing Lonsdale to discussion. This claim arrived out of the blue 3 years after the liquidation. As we say in the Statement of Facts and Issues, Lonsdale had made very clear that it did not accept liability to Bresco and that it had a cross-claim for damages which exceeded Bresco's claim. Now,
my point is that will have to be determined somehow, that dispute.
yes.
Adjudication seems a cheap way, but if you don't want to spend the cost of that, you're going to have to spend some other costs in getting it determined if there's no agreement. And so what's wrong with taking things forward in an adjudication?
My lord, because the alternative is legal proceedings in which Lonsdale could do two things. First of all, it could make its cross-claim. It won't be inhibited by the restriction that in adjudication it can only bring defences. And secondly, if Lonsdale is successful in proceedings, it will get an order for its costs. And yes, of course, it'll still be thrown back on the prospect of proving for those, but it will have a prospect of security for costs. And it won't have the sunk costs in adjudication, which in no circumstances could ever be awarded to it. So no party facing a claim by a company in liquidation and which has a cross-claim is in a happy position. But if those are the alternatives, then legal proceedings are plainly more acceptable. Moreover, because adjudication is an interim process, it's an addition to and not a substitution for legal proceedings. It is quite frankly, it's important to bear in mind that adjudication is an adversarial process. Typically, a responding party feels somewhat ambushed because it has a very short period of time. Now, that is inherent in the nature of adjudication, but it doesn't help to smooth the way to the parties reaching a negotiated settlement in the way that a longer period of time in arbitration or legal proceedings might, simply because, frankly, if the lawyers and everybody else are working overnight to get their response in within 7 days, there isn't a lot of time for negotiation. It's actually it's certainly not a good way to force a party into reaching a settlement. And because of the inherent inaccuracy that one can expect in the decision that's produced at the end, it's actually not a great way to bring about a settlement after the decision is published. My Lord Legate yesterday mentioned that he had read that only a small percentage of adjudications ever end up in final proceedings.
It was Lord Briggs, actually.
Oh, forgive me, of course it was. Forgive me. I don't know the particular article referred to, but as to that, I would say this. Presumably, a report of that nature can only be referring to information that is publicly available. So it might be able to find out how many disputes went to legal proceedings. Some disputes, of course, will go to arbitration. Some will proceed to a negotiated settlement. In fact, many adjudications are for relatively small sums. Parties might well think that the cost-benefit analysis doesn't justify further expenditure. The majority also, and this is reflected in the judgment of Lord Justice Coulson at paragraph 40, that the most common type of claim is an interim payment claim. By its nature, a resolution of an interim payment dispute is capable of being revisited when the parties reach final account stage. And so that there is not an abiding imperative for parties who are not happy with an interim payment decision to go to final proceedings. In other words, a low number of final determinations is entirely consistent with the adjudication regime operating in support of what we say is its primary, not its only, its primary purpose, which is regulating cash flow during projects. Now, what would be interesting to know, and I confess we've been able to find no information about it, is how many adjudications take place like this one years and years after the project has ended, years and years after final account stage. And in this case, as I say, years and years after the subcontractor, after one party has gone into liquidation. We don't know. Well, one might think that if construction adjudication was indeed a useful and obvious tool for liquidators, then one would see on a regular basis claims being referred to adjudication by companies in liquidation. One doesn't actually see it very often because liquidators know they're not going to get an enforceable decision. In effect, my lords, to use adjudication as a way of delegating, really, the liquidator's obligation to value or to estimate a claim, by using a process which offloads at least part of the cost to the creditor, is a misuse of the adjudication procedure. That's why Lord Justice Coulson in the Court of Appeal referred to it in terms as an abuse. Now, before I leave the jurisdiction issue, if I may, I need to deal with the Australian cases. I mentioned to you facade. Lord Reid. I can't hear you, I'm sorry. Thank you. Yes.
Can you hear me now?
Yes.
Before you go to the Australian cases, can I just go back for a moment to the point that was raised by Lord Hamblin about 5 minutes ago about, he was asking about the comments made in Murphy about Fiona Trust.
Yes.
It's occurred to me that there was some discussion of whether Fiona Trust applied to adjudications in the aspect contracts case in the Supreme Court.
Yes.
And I think we didn't have to reach a final decision, but our provisional view favoured the application of the Fiona Trust principle to adjudication.
My lord, it was my submission.
Yes, I remember that.
And I wondered if anyone would spot that point. It was my submission. It is not a difficulty, although I suppose I ought not to be held to my submissions in other cases.
No, of course not.
It's not a difficulty for me in this case, but for this reason. In aspect, the argument, of course, was primarily about limitation.
Yes, and the question, as I recollect, was whether a claim in tort, which was coterminous with a contractual negligence claim, could likewise fall within the scope of the adjudication clause.
My lord, that's right, because if it would, then there was an argument to be had about Section 14A of the Limitation Act and so on. So the limits of my submission in that case was that in a case such as aspect, where the contract was in effect a contract for professional services, an asbestos survey, one of those areas of work which is on the cusp, I suppose, construction and professional services, where there is a concurrent and coterminous duty of care at common law, the duty to exercise reasonable skill and care to perform the contract, a duty which only exists because of the contract and would not otherwise exist, then the relationship is so close that it was legitimate for the court to consider the limitation implications in respect of such a claim in aspect.
Perhaps we should look at what Lord Mance actually said. It's on pages 598 to 9
Grateful.
of
Yes.
the bundle. And we see about what opposite G, you submitted that that the coterminous tort claim was capable of being submitted to adjudication along with the contract claim. In support of that proposition, referred to Feely Shipping, which is another name for Fiona Trust,
Yes.
as superseding the earlier approach. Mr. Bartlett, Lord Mance tells us, did not accept that the approach taken in Fiona Trust would apply to statutory adjudication, but I'm very content to proceed on that basis. Mr. Bartlett went on to submit that this would mean that the tort claim couldn't fall within section 14A of the Limitation Act. It's unnecessary to say more than that I don't accept this submission, assuming, as I'm presently prepared to, that a coterminous tort claim can fall within the language of section 1081. It doesn't follow that it ceases to be a tort claim for limitation purposes. So there it is.
My Lord, yes, I would say simply that it wasn't necessary for me to submit in that case, and as I recall, I did not, that as a general principle, the Fiona Trust approach should be taken to the wording in section 108. All I needed to do, I had the support, I recall, of a decision in Scotland saying that a professional negligence claim could be brought in adjudication, that in English law, that in relation to that particular species of claim was an appropriate approach. And as your Lordship has noted, this court did not have to decide anything about it. It was willing to go with me as far as I needed for that limited purpose. Lord Briggs has a question.
Sorry, Ms. Sinclair, I hope this will be my last intervention. In fairness to you, the references that I made yesterday to articles and so forth, suggesting a very low incidence of challenges, are two. One is paragraph 5.53 of Kendall on Expert Determination, 5th edition, which puts it in general terms. The 2% figure was given in an article by David Adamson, the former deputy chair of the Construction Clients Forum, in a 2014 article in Building. I suppose you're familiar with the journal. My real reason for intervening was just to ask you one question about the way you put your case, that once there's a cross-claim, then there isn't and can't be a dispute under the original contract. Does that submission depend upon the cross-claim itself being disputed, or is it the mere existence of the cross-claim which has that effect?
My Lord, it's the mere existence of the cross-claim because insolvency set-off is self-executing. It doesn't need anybody to do anything.
Yes, I thought that was so. So it does mean, doesn't it, that say you had a £200,000 heavily disputed claim by the liquidator and a cross-claim for £10, which wasn't disputed, then that would take it out of adjudication. Whereas, but for the £10 undisputed cross-claim, it would still be in because there wouldn't be a cross-claim.
I have to accept that that follows.
Yeah, okay.
From our position.
Thank you.
Finally, just on the Australian cases, because I wouldn't want it to be thought that I took you to a decision which had been disapproved. That is not actually the case. I took you to the facade treatment engineering decision of the Court of Appeal of Victoria. The court in that case had two matters to decide. The first was whether, was a matter of construction of the statute, and the court referred to that as the construction issue. That is not of assistance in the current case, and I didn't pray it in aid, because it has to do with the particular wording of the statute in Victoria. The second issue the court had to decide was the consistency issue, which was precisely the clash between insolvency set-off, which was provided for by the federal statute, the Corporations Act of 2001, and the Building and Construction Industry Security of Payments Act, which was enacted in the state, in Victoria. And that was the issue on which we rely. The court there found there was a conflict, there was an incompatibility, and it's the same incompatibility that the court has found in this case and found in Wiegandal Jensen, at the very least as a rationale for the non-enforcement of adjudication decisions in favour of the liquidator where there is a cross-claim. Now, my learned friend referred you to Seymour White Constructions and Ostwald Brothers Property, a decision of a court at the same level, Court of Appeal, in New South Wales. That court did indeed say that the court in Facade was wrong, but it said that it was wrong not on the consistency issue, on which we rely, but on the construction issue. It has nothing to do with the current case, doesn't assist at all. And you will see that because the consistency issue had raised its head in the Seymour White and Ostwald case. The court decided it did not have jurisdiction to decide the consistency issue. And I won't take time now by taking it to it, but if I may give you the references. So if I could find them first. In the decision of Justice Leeming, it's paragraph 39 at bundle page 3176, where he observed that the argument on the consistency issue had been abandoned. And he said, in that unusual circumstance, I don't think it's right to express a view one way or the other as to the correctness of the constitutional aspect of the reasoning in Facade. And you see the same in paragraph 67 in the judgment of Acting Justice Sackville. That's page 3181. Now, what happened? Perhaps partly, well, by the statute which was enacted in 2018 in New South Wales, it was made express that an adjudication decision will not be enforced in favour of a claimant in liquidation. My learned friend said possibly in response to that decision. Well, it's difficult to see how it could be, because that decision said nothing on the topic. I won't tire your lordships by going through the provisions of the relevant state legislation. My learned friend mentioned them briefly. They are not the same as the adjudication regime we have under the Act, but they have notable similar features. There is a provision for summary enforcement of provisional payment, interim payment obligations. And so the court was looking in Facade at the correct interface. It's the interface between insolvency set-off and a regime which allows a contracting party, as it were, direct access to the enforcement powers of the court. Well, that's all I propose to say in relation to jurisdiction. In relation to the injunction issue, the appeal, first of all, again, I fear that Mr. Arden was addressing a submission which I've never made. He referred to paragraph 31 of Lord Justice Coulson's judgment, where the judge concluded that Bresco's claim had survived liquidation for all purposes, and Mr. Arden sought to challenge that if understood as meaning that insolvency set-off could have no effect on that claim. It's not a submission that I've made. Secondly, Mr. Arden sought to support the judge's reasoning that it cannot be appropriate, in order to decide whether an adjudication decision is final, to look at events which happen after the decision has been published. We don't quarrel with that. Our submission is, of course, that an adjudication decision is never of itself final. It might become final if the parties agree to make it so, but they're not going to do that in the normal way until they've seen it. And a final determination in litigation or arbitration doesn't do anything to the adjudication decision. It doesn't make it final. It substitutes it with a finally binding decision. My lord, so far as the tests applicable when the court is deciding whether to restrain an adjudication are concerned, my learned friend anticipated that Bresco would take the position that it could rely upon those cases such as Shell and Crease, which is at page 1317 of the bundle, to say that there was a jurisdiction to restrain insolvency proceedings, but that such a power arose only in exceptional cases. Again, that is not a submission that I made yesterday, and it's not a submission that is found in our written case. Shell and Crease is a case about the restraint of foreign insolvency proceedings, which were so incompatible, or this is the argument, is so incompatible with the English regime that that an injunction was justifiable, notwithstanding the very significant restraint represented by comity. That's not this case at all. My submission, except in the very limited terms, decisions about foreign proceedings offer very little assistance in a case such as the present case. And I made my submissions yesterday about why anti-arbitration injunctions are not a helpful source, because there are the principles of judicial restraint which are enshrined in the Act, because arbitration is consensual, as enshrined in the Act, and so on, and not mandatory, and because arbitration will result in a decision which will bind the parties, finally. All three major differences from adjudication, and an explanation for the restraint and the caution that one sees repeated in the anti-adjudication cases and the judicial statements there. Those three factors don't apply in this case. We say it's not necessary or helpful to go searching for or analogies, because the court in Twintech observed due restraint, recognised that the grant of an injunction to restrain an adjudication would be exceptional, but this is paragraph 63 at page 1381, recognised in terms that where the adjudication is not going to produce an enforceable decision, and that is an exceptional circumstance. And it is truly exceptional, because again and again, since the introduction of adjudication, the courts have emphasised that there are two circumstances in which a decision of an adjudicator won't be enforced. One is where he had no jurisdiction, and the other is where he acted in breach of the rules of natural justice. He did not operate with due impartiality. So it is exceptional to have a situation where, I'm so sorry, and apart from those two circumstances, the court will enforce an adjudicator's decision, regardless of whether or not it is erroneous, regardless of whether or not the error is as a matter of fact or as a matter of law, regardless of whether or not the error is patent. And this again and again, and as I submitted yesterday, the reason for that very generous approach to enforcement is the provisional quality of adjudicators' decisions. So, my Lord, given that, a situation where one can tell in advance that an adjudication is not going to produce an enforceable decision is indeed an exceptional case. And so Mr. Justice Edward Stewart in Twintech rightly observed that was the situation and that the court was being duly cautious. He did not limit his reliance upon the unenforceability of the decision which would be produced to unenforceability on lack of jurisdiction grounds. There's no reason to read his decision in that way. It's certainly the jurisdiction which he identified is certainly wide enough to encompass the current case. Now, the reason for the enforceability, I'm sorry. My Lord, I'm sorry, I can't hear you.
Sorry. If I could just ask you to clarify, when you're talking about a decision that can't be enforced or that's unenforceable, you don't mean a decision which is not binding, I take it, as if the arbitrator had no jurisdiction, there wouldn't be any binding decision. You're talking, for your purposes, about one that won't result in a money judgment, are you?
I'm talking about, yes, a decision which the court will not grant summary judgment upon. So for practical purposes, that is a money judgment or a judgment with obvious financial consequences.
So do you say that it's a general principle, whenever the court can see that an adjudication will not result in a summary judgment for a sum of money, it should grant an injunction to prohibit the use of the process? Wouldn't that be frustrating the statute?
My Lord, no, because in the cases where injunctions have been granted, Twintech and this one, there aren't very many of them, that is precisely what the court has done. It said the system is not going to, the process is not going to achieve its purpose in this case, because the purpose of adjudication is to produce a decision which will bind the parties. And if the court is not going to enforce the decision, is not going to allow a party to be compelled to observe the binding quality of the decision, then it's not achieving the purpose for which it was designed. So in Twintech and in this case, I think there are others where there has been no dispute about the jurisdiction. Mentmore, Packman and Lucas, I think, which is a case which was referred to in Twintech, but there was no argument that it was common ground between the parties that the court had jurisdiction to grant an injunction. So we don't have it in the bundle. So there isn't very much to go on. But But what we say is that the jurisdiction which Mr. Justice Anthony Edward Stewart identified and which the Court of Appeal in this case exercised is entirely appropriate, and that one does not need to go to other legal contexts in search of further principles. If we do, as I say, then, my Lord Reed, I can't hear you, I'm sorry.
Can I just mention you have to close your submissions shortly in order to allow Mr. Arden a fair opportunity to reply?
My Lord, thank you, and I shall. Lack of enforceability is obviously at the heart of the court's decision on injunction. And my Lords, it's important to understand why and how Lord Justice Coulson in his judgment arrived at the conclusion that he did. He didn't arrive at it on the basis of an obiter comment by Mr. Pearl QC in the Philpott case. He arrived at it on the basis of the unanimous position of the Court of Appeal in Bouygues and Dahl Jensen. And helpfully, the Court of Appeal's judgment quotes in full the relevant paragraphs of the judgment of Lord Justice Chadwick in that case. They're at paragraph 20, page 250 in the core bundle. And at paragraph 43, page 257, Lord Justice Coulson encapsulated what that came to. He said, the incompatibility between insolvency set-off and adjudication is also demonstrated by looking at what might happen if a company in insolvent liquidation was entitled to the sum found due by the adjudicator, but where the responding party has a cross-claim. As Lord Justice Chadwick pointed out in Bouygues, paragraph 20 above, if Bouygues had to prove their claim in Dahl Jensen's liquidation, it would only receive a dividend and would be deprived of the benefit of treating Dahl Jensen's claim under the adjudicator's determination as security for its own cross-claim. So the court's refusal to enforce a claim, an adjudication decision in favour of a company in liquidation where there is a cross-claim, is in protection, as it were, of the creditor's rights under the insolvency set-off. And the principle has been repeated in straw realizations, which is the case I mentioned to you yesterday. It's at page 2419. And in Mead and Dartmoor, page 3042. It might be worth actually just, if we may, very quickly going to Mead and Dartmoor, because that was a case which actually looked at the circumstances in which the Technology and Construction Court will grant summary judgment, but stay execution of an adjudication decision. My Lords, I'm in difficulty finding it. May I just give you the reference to paragraph 11? The point is simply this, that the court draws a stark distinction between the circumstances in which it will stay execution having granted summary judgment, which the principles are well established and they're fact sensitive, and the circumstances in which it simply will not grant summary judgment in the first place. It is, contrary to my learned friend's submission, nothing to the point that in Bouygues it looked as if the adjudicator had got it wrong. That is very commonly the case. It is no impediment to enforcement by the court at all. And finally, my Lords, my learned friend's closing remarks were directed to the suggestion, also in his written case, that the court should wait until the adjudication decision is published and and not intervene before that? The short answer to that is the answer that Lord Justice Coulson gave. Why should the responding party be required to invest its own resources to protect itself, increasing its exposure to the insolvency of the claiming party? We can identify all the ways in which the responding party ought to be protected. Those are the ways identified in Meadowside and in Balfour Beatty and addressed. They can all be addressed at the start of the adjudication. There's no reason to wait. My lords, that's all I propose to say in reply, unless there's anything further.
Thank you very much, Ms. Finkler. Mr. Arden.
I find myself in the odd and slightly unusual position of not really having, I think, anything that I can sort of usefully add to what I've already seen. Lord, I mean that with absolutely no disrespect. It's that it simply arises because of the course that these submissions have taken, which is that my learned friend had to do my appeal first, and so I've already had a sort of opportunity to reply. And I think that a lot of what she has just said has, in a sense, I've already tried to anticipate it. So it is no disrespect. It's simply the odd way in which the course of submissions have gone, which we hoped made sense, but inevitably one gets a sort of slightly odd bit at the end, which is me. So if your lordships have any points for me, I'm delighted to take them. But I really think I'd be wasting your time, because I think I would be repeating points that I've already made.
Well, brevity is never a problem from the court's perspective, Mr. Arden. Well, if there are no questions, and there appear to be no questions, I'll simply, if I may, thank you both for your very careful and very helpful submissions on both sides of this argument. The court will now take time to consider its decision. Thank you very much.